I have, yeah, I've been here 16 years. I've been a partner for 5. Um, so that's my background. I'm born and raised in the Seattle area, one of the few people left who were. I went to Blanchard High School and University of Washington, law school at Willamette University in Salem, Oregon, and back up here. And I always say every time I've looked for greener grass, it hasn't been greener. So I've been here at Beresford Booth for um, for my whole career, and my mentors are now my partners, and it's pretty fun. So the next slide, we'll talk about 1031s and Delaware statutory trusts first. So I'm sure I'm going to be telling people some things that they already know. So I apologize if I'm being too elementary or too complex. I'll do my best to be in the middle. So a 1031 exchange is a sale of a piece of property where rather than pay capital gain on the sale, you invest in a new piece of property. So you've got the relinquished property and what I call the target property. And so you don't get out of paying capital gain tax. You kick the can down the road until you eventually do sell. So you can defer and defer until you die. and if you die holding real estate, you win the race, and your heirs get a step up in basis. So if your basis is the where they judge the tax from. If you purchase for $50,000 and you've got mom and dad on Queen Anne Hill who bought in the 40s for 10 grand and now sell for 800, they're basically all capital gain. They might have a little bit of a shield against that if it's their personal residence, but there's a lot of capital gain there. Especially if it was an investment property, not a personal residence. So people very frequently want to sell real estate and avoid capital gain. So the 1031 exchange is the way that the IRS allows us to do it, with the policy reason being that they want to encourage continuous ownership of real estate. So the problem with a normal 1031 exchange is that you would have well, there's several problems with it. I mean, number one, you're still owning real estate and managing it. You're managing real estate, or you're paying someone else to do it. And the other, there are several main issues. The other is that the actual 1031 exchange transaction itself either leaves you you either come up with money to make up the difference for the more expensive property that you purchase, or you don't have enough. So you've got, instead of coming up with money, you've got a shortfall. So it's never, the target property is never exactly the right amount. So enter the Delaware Statutory Trust, and it's a relatively new animal. And it turns the target property. So again, you've got the relinquished property, the property you're selling, and you've got the target property, the property that you're buying. And in a normal 1031, you've got this tight timeline where you have to identify the target property within a certain amount of time. I think it's 45 days, and then you've got to close on it, I think in 60. I have to go back and look at my
180.
Timelines again. 180.
Yeah.
Okay, so you've got this timeline in which you've got to close. I'm not a facilitator. We hire facilitators. My clients do. But you've got this timeline to deal with, and then you've got to close within that timeline. With the Delaware Statutory Trust, you basically turn the you turn the target property into a stock almost, or a portfolio, you turn it into the S&P 500 or something, if you will. So similar to a real estate investment trust from your perspective, the seller, from the investor's perspective. So the way it works is you still go through a 1031 facilitator, and you still have a this property, if you will, that you close on, but it's not a single property. It is a grouping of pieces of real estate. It's typically not one parcel of real estate. It's typically a portfolio of commercial real estate from around the country that that's owned by the trust itself, the Delaware Statutory Trust, and then the DST has a manager. The DST itself has a manager, and that manager admits new people in with their money as beneficiaries of the trust. And the IRS says, okay, if you have that structure, then you can 1031 into that DST. It is a valid target property. And with the short version on the DST is, with the assistance of that DST manager, it essentially it's like buying a mutual fund or an exchange traded fund or something like that. It really is. Certainly it's not like that. It's not like you're owning stock or something. Well, what I mean is from the perspective of the investor, and with the relative smoothness of the transaction and the level of management that's involved, which is zero, it's a similar way to go in. So you've got again, you think of it, if you've been in a REIT, real estate investment trust, you're a part owner, and I'm talking a little out of school here, because you're not exactly a part owner. You're the beneficiary of a trust, and the trust is the owner. But from a functional perspective, you're a co-owner with the other beneficiaries of this portfolio, typically a portfolio of commercial property. Medical properties are a pretty popular one, and I'm sure there's people know a lot of other different types. I'm not an expert on the different types of real estate that are in DSTs, but the idea is that it's a diversified portfolio. So we'll go through the pros and cons.
Hey, Bill, can I interrupt a little bit there and see if I can clarify that a little bit? I see a few questions popping up. So if anybody's not familiar with a 1031, just to clarify that a little bit. So this is going to be a two-part transaction. Let's say you're an investor, you've owned this property for, like you say, your parents or whatever, you've owned it for years, you want to sell it. If you do a 1031 exchange, you have a timeline, you have to name the property, and then you have to close the property, but it's a short window. And obviously in a market like this, it's hard to identify those. And then also, you have to close on the properties that you've identified. So if you can't do that, then you have a tax liability. So a lot of people don't want to sell because they can't facilitate that first part of the 1031. So the DSTs are larger assets from large companies, corporations, whoever is facilitating these. They've gone through, they usually use an exchange, but you can sell your property and you don't have to go find properties, all of that. They have them already sitting there. And so then you can identify that company or that process, and you don't have to sell your property and just buy one, correct? You can split that up into a few different ones, I believe. But you can go to this
other multiple
company,
DSTs?
Correct. Multiple other assets. And then that way it's already there, it's already available, you know you can close on it so you don't run into that timeline. So you're selling your side, going into this other company that will facilitate you placing your money into other things. And so you don't have to manage it. It's all bigger companies managing, doing everything, operating at everything. You're just receiving a check. Is that correct?
You got it. Yeah, you're right on it there. Yeah. So that's right. You got no management. You got the proverbial mailbox money. Typically DSTs pay out monthly. So it's like monthly rent. They're performing, the ones I'm aware of right now. I mean, obviously things can change, but their performance right now is some of them are just amazing, 7-8%. It just throwing off a lot of cash, even net of the management fee. Again, no guarantee, but high performance right now. And then a big one too is the precision. So again, you don't have a shortfall and you don't have a makeup. So you sell for you sell for $1 million, but you want to target a property, and you're trying to target a property that costs exactly $1 million, but all you can find is 1.3. Well, now you're short, and you gotta you've got to come up with the money. Alternatively, all you can find, you sell for $1 million, all you can find is 800. Well, now you're down, and you've got some of the money that you're not able to park into a piece of property, and so you get taxed on some of that money. So you avoid that with the DST. You can invest virtually every penny directly in, no shortfall, no makeup. Slide. So there's, of course, downsides to DSTs. Of course, there's management fees. There'd be management fees if you hired a property manager. Some people, I suppose, don't like a lack of control of the investment. And you've also got a cycle, and I'm looking at this question that's popped up here, and I'm from Robert, and I'm gonna get to your question here, sir. So you've got this liquidity issue potentially. So it's not guaranteed, and it very much depends on how the DST works. They have a cycle. Depending on the DST, it can be somewhere between 5 and 10 years. And so you don't have guaranteed liquidity, but it's likely, and it's likely in the sense that once you see the performance of the DST, that at least these days, people are not keen to get out of it. But if someone is wanting to get out of it, other owners in that DST are able to buy that trust beneficiary's, what I mean is owner, but technically a trust beneficiary's interest, and they will there's typically a market for it, and they'll typically gobble it up. And some DSTs allow outside investors to buy as well. So guaranteed, no. Every DST manager I've talked to says you don't want to count on that. You want to count on being stuck in for the cycle. But as a practical matter, they have to be careful in what they say. But as a practical matter, you do have a market. So the question here is, how easy is it to move in and out of a DST for a 1031? For example, if I sell my existing property and I try to 1031 and do a DST, and then 6 months later, I find a new property and I want to move my investment from the DST to the new property also as a 1031, can I do that? The official answer is you can't count on it. The unofficial answer in this market anyway is you ain't going to want to, but if you do want to, people will be glad to snap up that interest. Markets can change, but right now that's it. And by the way, I'm not really following the chats as questions. So if you do have a question, please put it in the question bar. So we got pros and cons of DSTs, and so who might be looking for a DST? Somebody who's too busy to self-manage, not inclined to self-manage. Those people could be elderly or incapacitated, or they could be, when I say too busy or disinclined, a lot of times it's the adult children of older folks who own that real estate, and they're too busy in their own lives to be managing mom and dad's long-term hold property that's just got a pile of capital gain. So what do they do? Whoops, to do that. What do people do who are in, and the reason I'm bringing it up to you folks here, and I thought it's an interesting topic, is because we have low inventory. Even now, I think there's a little bit more inventory, but we're still in a low inventory market. And I think part of the reason for that is people are sitting here on all this capital gain, and they're just kind of they're just grinding. So I think the pros I just discussed for a lot of folks outweigh the cons. So you've got these would-be sellers, or their adult attorney-in-fact children, people operating under a power of attorney, and they're holding the real estate. And I really think it's, in a lot of cases, clients that I'm talking to, it's a needless hold. They're just what I call grinding out the management themselves, and just kind of gritting their teeth and going, man, I didn't want to be 75 and being a landlord chasing around clogged toilets. Like, what are we doing? And or they're paying a professional manager to do that, and they think, well, I've just got to die with this property, or their adult children who are helping them out go, well, I guess we just got to wait and mom and dad to pass so they can get the step up. And I say, what if I told you you could sell in a 1031, invest every penny with no shortfall, no makeup, manage nothing, and get mailbox money? I mean, I have told a handful of clients about this, and it's just, I had this gentleman who owned a really beautiful little building down by Green Lake, a nice little commercial building, and it was throwing off cash, but he's a hands-on guy, and he didn't want to have management for it, and had good relationship with the tenants, and as commercial buildings go, it wasn't that big of a hassle, but it was still a big hassle because he's managing a commercial building. They didn't even know about the DST, and I told him about it, and he researched it, and I just use him as an example. I've got 5 or 6 clients that have done this very recently, and he just kind of slapped his head and went, my gosh, I don't see why I wouldn't do that. He since sold, and this last, I think he sold 6 or 8 months ago, and that's thrown off almost 8% annualized. So, I mean, that's a crazy number, and it's not probably sustainable, but it's sure working for now. And even if it was half of that, it would be decent. So, so if for the folks who are in real estate, who whether you're an investor or an agent, or they're, I think if more people knew about the DST, we would have higher inventory. Yeah, ROIs on DSTs. I just saw this question here. What kind of ROIs are we seeing on DSTs? And that's what I mean. 8%. So, and I mean that as a function of the amount of money invested, throwing that off annually. And then I see another question here. Similar construction to a syndication program, with a primary difference between the the OYU can 1031 into a DST. Not so much. I guess I'm not familiar with a syndication program, so I can't speak to that. But yeah, sorry, I can't speak to that. Apologies. So let's see.
Quick there,
do we want to take questions on the DST?
Sure, real quick, I'll answer that one.
Go ahead.
Sorry. It's similar to a syndication, but again, syndicators, wide variety. It may be somebody first or second, it may be somebody much larger. And I don't know that you can 1031 into a syndication. And talk to your CPA on that, I'm not sure. One thing is, go back 4 months or so ago, and Frank Piscatelli, Archer Investments was the group that we had talk about that side of it, of the DSTs. So he can give you some information on that side of it and what they can do, and reach out to them too for that. But they'll have webinars, and they're usually very large managers, I'll call them managers, that are doing these projects that you can DST into. So syndication can be very small up to very large. Right, you can go, I see Scott, thank you, Scott. And if you want to jump on there too, tenant in common, but I don't think that's the same as a DST. There's something on that, and we can go back to Archer, and I'll try and clarify that. Real quick, also another benefit is, and again, it's in the RHA Rental Housing Association of Washington magazine, but it also has tax benefits with a Delaware statutory trust. Because they're not liquid for your estate taxes, and again, talk to your CPA, but for estate taxes, Washington is one of the lowest thresholds for estate taxes. But with these, if you have DSTs out there, they can be depreciated up to 30%, it says, when you go to transfer, because they're non-liquid. So it may be a benefit in your estate planning also with DSTs. Real quick, what did Scott say? It's Rental Association or Rental Housing Association of Washington, Sonny. It's another organization here, and they've got a monthly magazine that comes out, and that's where it is. I'll send me an email, and I can see if I can send you a copy of it. And
yeah, Jeff, that's a really good point on the estate planning piece too.
Yeah, that's huge if you're looking at estate planning type stuff. You can go. Is that Scott? I think that Scott said, yeah. You can go in and out of a DST or a TIC. You can set the syndication up as a TIC ownership agreement.
Hey, Jeff, they want your email in the chat if you could.
Yeah, I'll put that in there. Okay, Bill. Sorry.
Not at all. Not at all. Folks, feel free to bring me back to the DST. I'll march ahead here. I'm going to talk a little bit about boundary line issues and title issues. And I deal extensively with these. I litigate them. More importantly, I try to keep my clients out of litigation in them. So sometimes there's no keeping people out of litigation, and we litigate. But the goal is to keep things transactional, and litigation is just a transaction gone bad. That's going to end up being a transaction at the end of the day anyway. So, but I deal with a lot of this. So, oh, hang on. There's a question on DSTs. Can I speak on accredited investor status for DSTs? I don't know about recapture. I don't believe that there's any accredited investor issue with DSTs. I mean, people, if you want to, you can take. I think most of them have a floor of like 25 or 30,000 bucks. So you can take a pretty small amount of money and stick it into a DST if you're so inclined. Although most people I've seen do it for a few million, but it doesn't have to be.
And when they do a few million, are they usually, when they're doing a few million, do they tend to diversify among different DSTs or go into one?
I've just seen them go into one because the DST itself is pretty diverse. They usually have a pretty big portfolio. They don't have to though. I mean, a DST can own one parcel, so it really depends. And different managers have different DSTs going at any one time that have options there. And I guess I'm not grasping the recapture question, so I'll shelve it for now. So boundary line disputes, we've got a couple different kinds of claims, and I could talk forever on these, so I'll try to be really brief. And I apologize in advance. I'm going to have to assume some knowledge, and because it could take a long time to. Adverse possession is a couple weeks of law school, so I'll go quickly conceptually with it, because conceptually it's pretty simple. So there's a couple different claims. Most people have heard, if you've invested in real estate, you might have heard of adverse possession. These other ones are very similar claims, where you don't actually have to prove the full adverse possession: mutual recognition, acquiescence, estoppel, and ejectment. So I'll use an example here. I think it's the easiest way to do it. So this is an actual client of mine. Can you see my cursor?
Mm-hmm. Yes.
I hope. Okay, good. So this is my client's house, and this is a big condo development project. And if you can see the GIS boundary line right here, can you guys see that boundary line?
Yep.
Yes.
Okay, good. So these folks come in, and this is this real steep slope right here. It drops off pretty steeply, and they've just never platted it. I don't know if they could and build on it because of the slope. They'd probably need some dirt moving, a lot of dirt moving. And these folks inherited it and just kind of sat on it. So they haven't bothered to plat it, but these guys came in, built their condo, and if you can see this, that right there is a pretty good size encroachment because this is a large lot, as you can tell. That's a decent sized single family home right here, and there's a really big lot. So these guys come in and encroach, and they build a big old retaining wall. They've got slope issues here too, and my clients wander down there one day and say, "Hey, I think that's our property," and a survey reveals, by golly, it sure is. So by several feet. And you'd think that somebody developing a multi-million dollar condo project would be right on their survey, but these folks are definitely not. I don't know what their motive was, but they've got a very large lawsuit on their hands, and it's over. That retaining wall starts here and it punches in, and you can see on here where it does punch in, and it goes all the way down, and it goes in these people's property too. But they don't care, which is weird. But it goes about there. So there's your encroachment. So my client has a claim for ejectment. Ejectment is a lawsuit where some people confuse ejectment with unlawful detainer or eviction, but ejectment is just a lawsuit where you're asking the judge to order someone off your property. It's for an injunctive relief or declaratory relief, if you will, and it's in order to pack up and leave and restore the property to the condition that you found it in, or to pay the plaintiff to do that. So so we have a claim for ejectment. Let's see. Here's another example, and this is my client here, and this is the neighbor here, and you can see the neighbor's RV peeks over here a little bit, but what you can't see is that there's a good size chunk of this driveway that comes down here and encroaches, and then they've cleared some land underneath the trees, and the kids played there for a very long time, and so these folks have been there a while. My folks just bought, but the guy who was here before him never really paid attention to his boundary line over here. And so these people had a claim for adverse possession. So adverse possession means that you have occupied a piece of property for 10 years, and if you remember an acronym, it's OCEAN, OCEAN, open, continuous, exclusive, adverse, and notorious. And really what it means is that you've taken a piece of property, and the key is without permission, initial permission, not midstream permission, but initial permission. And you've used it in the manner of what they call a reasonable true owner, and you've done it openly and continuously and exclusively. So the true owner, this guy's called the true owner, and this guy's the adverse possessor. So you've done it openly, continuously, and exclusively, and for 10 years or more. And on the 365th day of the 10th year, in theory, the ownership transfers from here to here. So it's conceptually pretty simple, but in practice it gets very complex. The other similar claims, one is mutual recognition and acquiescence, and that very frequently comes up when you have some sort of boundary line or some sort of physical mark on the ground that everyone has just sort of agreed and treated like it was the boundary. Mutual recognition and acquiescence wasn't a very good claim by this guy against my client, because my guy didn't do anything to to recognize. Mutual recognition and acquiescence means that both owners take some sort of physical marker on the ground and they go, all right, we're just treating this like the boundary line. We don't really know where the boundary line is, and we haven't made an agreement of any kind, but we're gonna treat this spot on the ground like it is the true boundary line. And then you get out of the rigid test of adverse possession. It's actually an easier way to take the property. It still has to go on for 10 years, but it's an easier way to take the property. The other one that kind of goes hand in glove with those is called estoppel in pi, for some Latin, and that estoppel means in the law, estoppel means you can't take a position later that's inconsistent with something you did earlier. So if you say if you did something that shows that you think that a spot on the ground is the boundary line, you can't later go back and say, wait, that's not the boundary line. So I've got a client right now who his neighbor built let's use this boundary line as an example. He built a nice little fence, and it met up really cleanly and nicely with a little rock cinder block parking area that was for my client, and it was one nice pretty little line that went all the way to the backyard, and the neighbor did it. Well, he did it a long time ago, and now he's like, oh, I don't like the fact that I just got a survey and found out that I put this in the wrong spot. And so he's claiming ejectment. He's trying to kick my guy off of, but the neighbor who's suing to eject my guy is the same guy who laid that whole line out, and now he's trying to prove, he's trying to beat adverse possession. And I go, I don't care. You can beat adverse possession all you want. You are estopped from claiming, estopped equitably from claiming that you get to grab back that land that you gave my client 13, 14 years ago. It's still a 10-year test, by the way. It's always a 10-year test, but there can be different elements. So that is, I guess the moral there, go back, hang on. Okay, so the moral here is boundary line disputes come up a lot, and if you folks see them, they can be large, they can be small, they can be obvious, they can be not obvious, but we do a ton of these, and if you're an agent, the key is you comply with your duty. If you say, hey, go talk to a lawyer, there is in the RCW for real estate agent duties, you basically kind of get out of jail free card and on your fiduciary duties, which are now reduced to statutory duties, but you have kind of, like I say, it's a get out of jail free card if you advise a client in writing, go talk to an attorney about this issue. And very frequently, these boundary line issues are there, and especially they crop up a lot in Form 17 too. So we litigate them on the seller disclosure statement and the Form 17. But for sure, the reason I bring them up here is not to educate about every possible kind of boundary line dispute and how to win a piece of litigation, but to just be able to issue spot it. And when you see an encroachment or even the possibility of one, something that just doesn't look right, that's something to figure out. And if you're an investor, same thing. You might be adversely possessing, and you might be being adversely possessed against. But either way, you might not care. You might care. Your neighbor might not care. Your neighbor might care. But you ought to get eyes on it and consult on it. And it doesn't take very long to break down that analysis options. Okay, so I'll move on to something we do called the friendly quiet titles. This is more of a boundary. This is not really this is more transactional and less litigation, even though it presents as litigation. So it's the friendly quiet title. If you've ever seen anybody try to adjust a boundary line, You can do that with something called a BLA, where you go through the city or the county, and they adjust the boundary line. You apply. You don't get it by, it's not as a matter of right, but the county, if the county wants to and feels like it, they can allow you to adjust your boundary line, you and your neighbor. Of course, it takes agreement by the neighbors. So this is a client of mine here in Edmonds, and this is the neighbor, and you'll see this GIS line right there, nice and clean, equal size lots. Well, this lot used to be, this boundary line used to be right there. And this neighbor was kind of sick of the yard. This neighbor had like 4 kids and went, I live on a postage stamp. This doesn't work very well. Well, they had a little bit of an encroachment. The fence used to run. I think they've taken it down, but the fence was right about there. And we had a survey, and there's a little bit of encroachment. And so they could have tried to adjust the boundary line and ask the city of Edmonds, and kind of approach and I don't know if anyone's ever worked with the city of Edmonds, but they pride themselves in being difficult, as far as I can tell. And so they could have asked for the BLA. I don't think, I have to go back and look at this particular case. I think there was something that would have prevented them from getting it, or it was a low chance that they would get it. So that's your city BLA. That's a downside of it. The other way to adjust a boundary line, a lot of people know about, is this RCW, which is to be avoided. It allows people to adjust their boundary line by recording a contract, and then recording the record of survey and the contract, just announcing what their new boundary lines are. I say never ever. I love it, actually. I would love it, except the title companies won't insure on it. If you adjust a boundary line with 5804-007, I call it the 007 agreement, don't use it. Title companies have uniformly told me they won't insure. I had a lawyer who said, well, my gal will do it, she'll do it, they'll insure for me. I went, oh, this is not good. So he drafted the whole thing up. Sure enough, we went, and Old Republic said, we won't do it either. And I said, well, you can join Fidelity and Stewart and Rainier and the rest of them, they won't do it. So avoid 007. So now you have a third way, though, to adjust a boundary line, and it's what I call friendly quiet title. It's a quiet title lawsuit. It sounds expensive, it sounds lengthy and scary and bad, but it is the slickest way to adjust a boundary line. So in this case, I use this example. We found this encroachment. It started out no encroachment here on the east side, and as you got to the west side of the lot, it became about 1 foot, which, by the way, is extremely common, as anybody knows who's gotten a survey. Most suburban lots or single-family lots have a little bit of an encroachment, and everyone just sort of ignores it, and it doesn't matter. But what you do to settle an encroachment is completely up to the two parties. So you file. What we do is we file the lawsuit, and at the exact same time we file the lawsuit, we walk the settlement agreement into court, and the judge adjusts the boundary line by signing the order. And the order says, here's what the boundary lines and here's what the two parcels used to be, and here's what they and then there's a stipulation that says we want them to change to this legal description, and so the court order says, hereby these boundary lines are now changed to this. So we had a dispute, and in fact, this gentleman was adversely possessing against our guy by a solid foot, and he had he had a total good claim to that. Now, he didn't know it, but once he found out, he had a legitimate dispute, and how you settle a dispute is completely up to you and the other party. And so they moved the boundary line all the way here, about 6,000 square feet of swing. And Snohomish County Superior Court's judge's signature is on there, and that is going to adjust your boundary line more completely and certainly with more certainty even than a a city or county BLA. So title companies love it. It's a good way to adjust a boundary line. I throw that out to say you can do this in the friendly context, or I've done it plenty of times in the non-friendly context where it didn't start out as an attempted transaction. It started out as a dispute. So something to keep in your back pocket. It's also, there's advantages, by the way. It's about the same cost at the end of the day as a BLA. It might be a little bit more, but it happens in a matter of a couple weeks instead of a couple months, and it happens for sure. There's no denying it. The court is not going to deny this. There's also no analysis of compliance with zoning restrictions, so you can create yourself a non-conforming lot if you want to. That's a big. You got to know what you're doing. You've got a lot of firepower with this thing, so you don't want to create a non-conforming lot unless you intend to. But a lot of times the parties intend to do just that, and there's no denying it. There's no city or county denial of that when you go through the courts. I got a question. Is it correct property owner getting the larger property also pays the other property owner for the, oh yeah, certainly there's, yeah, that's right. Certainly they agree on whatever the deal was. So this gentleman paid this gentleman the agreed settlement price for that. Yes, absolutely. That was part of the settlement agreement, was payment for sure.
So in making this happen, you're probably having a survey, you're having someone write up a legal description, you're having an agreement about the amount of cost. Is there anything I've said right or wrong there?
That's exactly right. So it's the same survey that you would get if you had a regular city or county BLA. It's the same survey you would get if you had the 007 agreement, because you need to legally describe what I call the chunk or the sliver. So the court says old legal was X for the two properties. Sliver is Z, legal description, and new legals are Y. So that's those three: old legals, chunk, and new legals are inserted right into both the stipulation and the order, which is just one document. Does that answer your question?
Mm-hmm.
Okay. All right, bring me back, please, to any of those issues, but I'll roll on to title here. How am I doing on time?
Good. We're at 8 o'clock.
Okay. All right. I'll try to wrap up here. So we've got title issues. One really common one. I do a lot of title clearing work, so I'm hired by or title companies will refer folks to me to clear off the title so that they can close. The most common one by far that we deal with is unreconveyed deeds of trust. So you've got so a deed of trust is a mortgage. As most people know, we don't use true mortgages anymore in Washington. We use something that I do not like the name of them, deeds of trust. People like, it's a deed? Like, no, it's a security vehicle to secure a promissory note. Well, is it a trust? Nah, not really. So I'll start with that. A deed of trust is just a mortgage in function. So if you've got a typical bank transaction, the first bank is paid off by the new bank. So the seller sells, the buyer buys, the buyer's bank pays off the seller's bank, and the seller's bank, which most people don't know in the background there, within the first couple weeks typically of the closing, the seller's bank will record a reconveyance of their old deed of trust, meaning they strip off their old deed of trust because the new one takes its place. Well, very commonly in seller finance transactions, you'll still see there's two ways to secure a seller finance transaction. One, the most typical one is just a note and a deed of trust, the way banks do it, and you'll see these old deeds of trust. So the buyer goes down the road and a few years after closing makes the last payment to the seller and says, there you go, seller, last payment, free and clear, all right. And they have a nice phone conversation, and that's the end of it. And everyone forgets to have the seller strip off that old deed of trust, and there it sits since 1968. And Grandma and Grandpa have had a free and clear house since 1968, and it just sits there. And sometimes, not that old, not nearly as old as 1968. You'll see even newer ones. But so seller finance transactions, that happens a lot. The other, you'll see old what are called real estate contracts as well, that are those have their own lingo. A real estate contract sounds like a purchase and sale agreement, but it's not. It's just a different way to secure a seller finance transaction. And so you'll hear words like forfeiture instead of foreclosure, but it's the same thing. Anyway, the point is you'll have these old seller finance instruments on there, and oftentimes we'll try to keep it out of litigation by going to for example, the heirs, the children, even the grandchildren of the folks who bought the folks who lent the sellers, because the sellers are not alive anymore to sign a deed of trust, or no one can find them, or they just won't call us back. And sometimes we have to dangle a little bit of cash out there, but that's better than the legal fees that it's going to take for a quiet title lawsuit. So that's a pretty common thing that we deal with on reconveyed deeds of trust. They have an opportunity the risk, I should say, of hanging up transactions and preventing closing, but usually we're able to get around the slowing down of the closing with a holdback, and most title and escrow folks are pretty good about closing with a holdback. And there's so much equity typically in properties these days that they do a little bit of math and go, well, the worst case scenario is a couple $100,000, and it's not likely, but it's a worst case scenario. So they'll hold that back until we're able to strip off the old deed of trust. So long way of saying, if you find one of those in a preliminary commitment, you want to immediately figure out with title and escrow if they're willing to close with that in place, and if they are, then what does the holdback look like? So another thing you might hear of is a lis pendens, which is a document that we lawyers file at the beginning of litigation if we're going to fight over who owns the property, who has title. So there's some situations where you've got title issues, and the most common ones that you've got co-owners, or you've got multiple people on the deed together, tenants in common. The most typical way that people are on the deed together, they're true old school co-owners. The deed says from Jim to Steve and Mary, and Steve and Mary aren't married, and then Steve and Mary are just arm's length investors. They're tenants in common. If you're tenants in common and you don't have a tenancy in common agreement that eliminates your ability to partition, then you have the absolute right to partition, meaning to sue to force a sale of the property if you're co-owners with somebody. And I've done a lot of partition litigation. As soon as you file a lawsuit for partition, you record as the plaintiff, you record a lis pendens. And more lawyer Latin for putting people on notice that there's a lawsuit, notice that there's a lawsuit pending. Meaning if you go and sell and close, then that buyer takes subject to the result of that ongoing lawsuit and whatever interest that plaintiff comes up with. So as a practical matter, you stop any kind of full fair market regular sale with a lis pendens until that lawsuit is figured out. So another reason why you might have a lis pendens other than a partition, sometimes you'll see folks claim constructive trust. So it's this idea that there's some sort of verbal agreement. Usually it's verbal, or it's in these days, a string of texts or emails or whatever, that one person who's not on the title typically lives at the property will pay some of the mortgage, they'll maintain it. The most important thing, they'll improve it. They'll put some sweat labor into it. I see like nieces, nephews, and children even, or you know, some friend of the family who's living there and does some work, and there's so much equity now these days that that we see these claims popping up surprisingly frequently. So constructive trust is a reason that you can get a lis pendens on the property, and then resulting trust is kind of similar. It's a little less common, but so you've got one person who took the deed, but someone else who paid the purchase price, and that person can come along and claim that, again, that there was some sort of non-explicit or non-obvious agreement between them about ownership, regardless of what the deed says. So that's a title issue that we deal with also, both on the plaintiff side, so suing and recording lis pendenses, or defending against claims, representing the defendant as well, and pretty common title issue. Another cloud on title, I don't have any subheadings under this, but another cloud on title pretty obviously is money judgments. So A sues B, and A gets a judgment against B for $100,000, and as soon as you get that judgment entered, typically you belt and suspenders, you record that judgment against the property in the county. Wherever the real property is, it becomes a lien against the real property in that county, so long as it's recorded in the county and is also filed in the Superior Court of that county. So one judgment from any county in Washington can be recorded against another, and frankly can also be recorded and entered into into the trial court of any state in the union as well. So can become a cloud on title in any state under the full faith and credit clause of the Constitution. So a money judgment is a big deal. It's a cloud on title, and we very frequently will record those. We'll bring them in from anywhere in the country and get them recorded and entered properly in the county when plaintiffs come to us with money judgments from other states, because they very frequently want to tie up Seattle area real property with the giant amount of equity that we have. I just settled a case. It was $40 million fraud judgment out of Florida, and the guy we found out he had bought a couple properties inexplicably. He bought them in his own name, in one in Kent and one in Seattle, and they're each worth like $1.5 million. And oh my gosh, we just recorded them against him and started foreclosing the judgment, started executing on the judgment, and lo and behold, there's your settlement. So the judgment's a powerful tool. It might start off unsecured, without a deed of trust, but once it gets reduced to that money judgment, it's a lien. So yeah, we deal with easement issues as well. And you folks might run into those, easements or lack thereof. That can be a real problem. You've got ingress and egress issues. So you can have an express easement, meaning an easement that's recorded. It could be an easement that's on the face of the deed. It could be an easement on the face of the short plat. It could just be a standalone document that's separate from both the deed and the short plat that is its own easement. And then there's what's called a prescriptive easement. So that's an easement. Go back to the adverse possession analysis and the OCEAN acronym: open, continuous, exclusive, adverse, notorious. But you just eliminate the exclusivity element, and that's basically a prescriptive easement. So it's all the elements except exclusivity. So you could have two parties that come and go on the same driveway, and again, you do it for a period of 10 years. And even if 2 or 3 or 4 or 10 parties are doing it, so long as that one party is is doing it, they can acquire that prescriptive easement. But again, if they want to prove it, and everyone's not amenable to giving it to them, then they've got to sue to prove it, and that can be a difficult thing in practice. Parking easements are fascinating. So frequent to see, especially in the commercial context, to see people parking where and just assuming that their building has the right to parking, and they don't. There can be, I could go on and on about crazy parking stories. You just think that was way more squared away than it is, but we litigate that. So again, the lack of a parking easement is amazing. Ingress egress, not the same as parking. Good for you. You get to come and go. Do you get to park? Those are different. And then you'll see landlocked properties, and a lot of people will talk about easements by necessity. And they think that if so long as you're landlocked, you automatically get an easement by necessity, and that's not true. The only way you get an easement by necessity is if you had a beautiful picture here. You've got this parcel, say this guy was landlocked over here. The only way you get it is if 1, 2, 3 were all one parcel, and then the single owner of these 3 short platted and created 1, 2, 3, but then left this one landlocked in my example here. And then this one can sue for an easement by necessity to typically the nearest and most convenient method of ingress and egress. But number one, that's not a slam dunk, and number two, that's a ton of title research, and what you very frequently find is that it wasn't kind of one fell swoop short plat. And then what you might have is just landlocked property. That's one of the more common misconceptions I run into, is that any landlocked property just automatically gets an easement by necessity. I just defended a claim for that by somebody who thought they had won the lotto by buying this beautiful piece of property on the Skycomish River, and it was a gorgeous piece of property. And they just started coming and going across my client's property, and we have an easement by necessity, and no, you don't. And so the title research revealed that. So what's the solution to all these title issues? Again, I touched on it before. Hopefully there's a holdback preventing the delay of closing, and then whatever happens, whatever the resolution ends up being, some sort of negotiation, or maybe it's litigation and then negotiation, or whatever it is, but that should happen on the back end. But that's totally up to title and escrow on a case by case basis. And in a worst case scenario, someone's going down the road toward their sale, and title and escrow won't let them close. They say, hey, you've got to resolve this first. The lis pendens is the most common one. Very infrequent that title and escrow are going to close the lis pendens sitting there, because it's not just a lien. It's not just a money judgment or a lien for money. It's a question of who owns this in fee simple. That's the question being owned. So who has the right to even convey title to this proposed buyer? So you don't see a lot of closings with holdbacks when you have lis pendens. Do I have a resource for collecting judgments specifically from past tenants who probably does not own real estate? Yes, me. I sue to collect judgments all the time. If it's a big enough number and we determine that the old tenant is solvent, I mean, that's the big issue. It's got to make sense to pay my rate, even if I have my law clerk take the laboring oar. I mean, it's still, it ain't cheap to hire a lawyer generally in the context of a small. I mean, it is in the context of a 5 or 6 figure or more fight. But if it's a couple $1,000, you're looking at small claims court up to 10,000. By the way, small claims court has moved from $5,000 to $10,000, and that's huge, I think, for your average residential landlord. Small claims court is slick. I love it. Lawyers aren't allowed in it, but I love coaching people through that. It's a good tool for if you've got a little time to chase a deadbeat tenant who might not really, who might have some money. So yeah, we'll determine the. Sorry.
Hey Bill, they had to raise it from 5 to 10 after almost 2 years of no rent from COVID.
Yeah, I think they actually did it before COVID. California had raised it to 10, and I just went, oh my gosh, this makes so much sense. I'd see the folks in California would have that opportunity, and sure enough, our legislature kicked in. The only time you don't get to, if you're still capped at 5 if you're an entity as a plaintiff. So if you're an LLC, you're capped at 5. But if you're a human pursuing a claim, you get to go to 10. So yeah, that's interesting. But if you start getting to like 20 or 30, especially like $30,000, that's where it starts penciling for me to go collect a judgment. But otherwise, there's collection agencies for.
Hey, Bill, I found it very interesting where you talk about the money judgments and reaching across state lines. So what kind of came to my mind is many local investors might be going outside of the state to get properties now, right? So areas. And so what it sounds like is if you had a scenario where maybe you have a multifamily in a lower cost state, and let's say there's a money judgment due to maybe a personal injury or what have you. And so it sounds like from what I understand you saying is that they could reach out to any properties you have anywhere in the United States, even here locally. They're not just restricted to that state. Is that correct?
You're talking about if the tenant got a judgment against the landlord?
You're talking about a money judgment. So I'm not sure who all that would apply to, but if someone were to get a money judgment against you or to put a lien on your property.
Mm-hmm. Yeah. So the typical example I'm thinking of is that landlord. That landlord invests. Let's say it's a Washington landlord and a Washington tenant, and then the tenant runs off. The tenant moves to California. But the Washington landlord has already obtained a money judgment in Washington for the back rent. First of all, it runs at 12%, which no other investment is running at a guaranteed 12%. You don't have guaranteed collection, but you have guaranteed appreciation of the debt. So it's typically 12% unless the lease says otherwise. I'm using a landlord-tenant context for a money judgment, but the judgment could arise in any context. Then you take that Washington judgment, you go record it in whatever county, wherever their own real estate. That tenant, say, gets on their feet and buys real estate in California. Well, you get to go lien that property in California. Or it's a business dispute and one person sues the other and gets a money judgment in Massachusetts, and then one of the judgment debtor moves out here, buys some real property, same thing. So a judgment from any state can follow a landowner to any other state if they own land. You don't get to move to another state and buy real estate and get out of your judgment debt from a different state.
And does having an LLC really protect you, or I know your example was that he bought the property in his own name, but a lot of people talk about getting LLCs and whatnot. How does that help, if it does?
Yeah, well, your first example is how it helps. So more for the landlord. So the landlord goes in Massachusetts, suffers a money judgment, and hopefully only against the LLC. now the landlord lives in Washington, you don't get to take that money judgment against a Massachusetts LLC and go execute on the landlord's house in Washington or in Massachusetts or anywhere, because you've limited that liability. What you might be able to do now if that same judgment debtor though goes and buys a piece of property in an LLC, you could go domesticate the judgment from, say, Massachusetts to Washington. They've fled to Washington. They've got a money judgment against Bob Smith, Bob has now bought a piece of property through an LLC in Washington, and he goes, I'm free and clear. Not true, because the money, the judgment arises, in my example, to Bob himself. The liability isn't limited to the LLC. The liability is that owner's in the first place. So you go get what's called a charging order if you have the money judgment against the individual human, and you get the charging order against their LLC membership interest. But again, if you can limit the judgment to being only against the LLC and keep that liability limited to the LLC, you protect from piercing through the LLC to Bob. What it's harder to protect, and you can still do it a little bit, but what's harder to protect is when the liability arises from Bob and then pierces through what we call reverse veil piercing into the LLC. That's to protect. The judgments are powerful. They're good tools. Any other questions? There's a whole chat. Are there any questions?
You're on mute, Angelique.
Okay, I've got a personal question that will apply to some people. I had a plumber not complete a job, and they're demanding full payment for the job as if they did the whole job. And I didn't pay for the whole thing. I thought I was very generous in what I did pay, and they've now leaved me. So how do I go to remedy it? Do I go to small claims court, or I was reading online, Superior Court in the county?
Yeah. So a lien is so it's a mechanics lien. It's called a mechanics lien or a materialman's lien, but most people refer to it as a contractor's lien under RCW 60.04, and that is those liens are very frequently improper. So the only way that what was your contract price? What was the?
Oh, it was very small. It was $6,700, and they did, let's say, $4,700 worth of work.
Right. And it was your personal residence?
Yes.
Yeah. So they have to give you what's called a notice to customer under Title 18. I can't remember which one, but if you Googled RCW notice to customer Title 18, it's under there. And they have to give you this before they start work. And it's a statutory form that is very, I mean, there's no wiggle room to it. It says, it's big letters at the top, notice to customer. So look at your contract and see if that's in there. And then it says your property may be lien in bold. And I mean, it's like there's no missing it. If they didn't do that, then their lien is improper, and it's actually a misdemeanor to record that lien. And if you have to sue to strip it off, by the way, you can't strip it off in small claims court. You'd have to hire a lawyer to do it in Superior Court. So that's the downside. The upside, though, is if you have to do that, then you get triple damages because it's a Consumer Protection Act violation, the CPA, which is if you look at RCW 19.86, that is the statute that is ton of teeth. Triple damages up to $25,000 extra and all your attorney's fees. So a solvent contractor who files an improper lien without giving you a notice to customer is entered a minefield. So the downside, you might have to pay a little bit of money to start that lawsuit, but once that hook is in, you don't have to settle for less than every dollar your lawyer is billing you, and that goes up every day, as everyone knows. So there's a ton of teeth to the improper lien statute. And they also have to record their lien within 90 days of their last day of work. And a lot of contractors screw that one up too, even if they do give you the pre-claim lien notice. But happy, feel free to call me. I'd happy to chat about that, because I love going after contractors who try that. Fun. Anything else? Anybody? Missing? Edit tech. All right. Well, here's my info. Feel free to call me anytime with questions. I always tell people I don't bill for my time unless you hire me. So I have this perverse incentive to not hire me. So feel free to call me anytime without the risk of owing me money when my phone rings. So.
Perfect.
We have somebody that
everyone,
said,
thank you for having me.
Thank you.
Appreciate it so much. Merry Christmas, everybody.
Thank you for joining us.
Yep.